We're just going to wait just a moment, let a few people join here. We have a few things to talk about, particularly what is a law and how is a law made. Particularly what is a law and how is a law made. There's been some recent things that have happened with the administration, and it's really interesting. And it's certainly worthy of talking about because it coincides with the work that we're doing, and I want to kind of bring it up with you guys. Another thing we're going to talk about is the right to travel. That's such a huge thing. You know, everybody keeps hitting me up for this right to travel, and again, this also coincides with the work that we're doing. So we're streaming to multiple platforms. If you guys, if you like the things that said, you guys want to rewatch this, it is streaming to YouTube, and that will be there permanently. We're also out on Instagram now, so streaming Instagram. And then, of course, Facebook will have it available for another 30 days. So those of you that are on TikTok, if you guys want to go out, rewatch this, or, go back, take notes, you missed something maybe, then you do that. I would allow people to come up on screen, but it's going to have to be people that I know, right? Because I don't trust unknowns. Unfortunately, we've had a lot of issues with people putting obscene video up on our Zoom calls and other things, and that is unacceptable. So we want to make sure that that we don't do anything that could potentially get the account banned, and also people that we just flat out don't know. So if you guys ask to join, if I don't know you, then I will not be bringing you up on screen. But if you guys do want to come up, I would like you to come up. You guys can ask questions. The questions that you guys ask, I'm going to every single time circle back to the litigation that we have, and so I'll explain that in just one moment. But the Zoom links. So we only have about an hour before Jessica starts her weekly Zoom meeting. So if you guys want to join that and participate and learn a little bit more about what we're doing on the service side, you guys can jump off. But what is going on here?
Listen, I'm just a messenger. Don't shoot.
For some reason, we just got kicked off of her TikTok account. That's weird. Okay. Okay. So, all right. So, my name is Tanner Downing. I'm sure that you all know me. I'm a civil rights advocate and litigator out of Washington, D.C., and we are in the middle of litigating the biggest civil rights case in American history. This is hands down. This is so huge. But a lot of people talk about the fact that I've been doing this for 9 years, and look, he hasn't done anything, Guys, what I got to say to that is, how many times did Thomas Edison fail at the light bulb before he finally created something that was useful to us every single day? 50,000 times more, So the thing is that it may not appear as though it's working, what we're doing, right? You guys may not see that we've gotten, these public officials to actually step up and do the honorable thing and, act the right way and obey the law. You guys may not see that, but that doesn't mean that it's not working. You see, the thing about Thomas Edison, Benjamin Franklin, these people that they believed in something. They knew that they were right, and it didn't matter what the critics or cynics said about them. They knew that they were going to be successful. And the difference between success and failure is one more try. That's it. One more try is the difference between success and failure. We have served over 100 different cities and counties. I mean, that's where we're at. You guys can see, the numbers that we've done. We are getting better and better and more effective, right, as we do it. But we're also seeing change that you guys can't see quite yet. We're seeing change from the behavior and activity of the administration in what they're doing, right? We're seeing change within the court where the judges that are refusing to recuse themselves are suddenly recusing themselves. We're seeing change where people, fathers and mothers who haven't been able to see their children for years, suddenly, are able to have visits with their children. We're seeing change. We've got senators that are calling us up. We've got representatives that are calling us up. We've got a lot of things happening. All right. And just as most of you probably already know, just the other day, over Thanksgiving, we spent the week, with a representative, right? This representative was very, very interested in what we were doing. And this representative is actually going to help draft an amendment to a state constitution and propose it in the next legislative cycle to comply with the Fifth Amendment, the Constitution, this particular indictment by a grand jury issue, right? Because he believes in it. He agrees with it. It took a week of spending time with him explaining what we're doing and why we're doing it. But now he's willing to do it. He also just so happens to be one of the founders of Project Veritas. And so, we've got some great contacts there with the media that might be able to help us get this out. But what you guys need to understand is that I know I'm right, 100%. I know that the law is on our side. I know what the law says. I know the Constitution as well as anybody in this country. I would challenge anybody on their knowledge of the Constitution, not judge-made rulings, the Constitution. What is the law, right? Because the Constitution is the law. Judge-made rulings is not the law. I don't go to them. I don't give a shit what a judge says. I give a shit what the people say, because the people reserve the right to be able to create the law. That was what we did. We did not delegate the power to create law to the judiciary. We did not delegate the power to create the law to the administration and the executive. We reserved it to the people. That's why the very first provision in the entire Constitution of the United States of America stated just that all legislative power is vested in a Congress of the United States consisting of a Senate and a House of Representatives. It was such an important thing that we reserved the power to make the law to the people, that became the very first provision that our founders and forefathers wrote into the Constitution of the United States of America when they drafted it, right? It's such an important thing to understand. We did not delegate the power to create law to the judicial branch nor to the executive branch. And that kind of is interesting because right now, I had someone just the other day that talked about how the administration just wrote an executive order that after the first of the year, people are going to be able to travel in their vehicle without a driver's license, right? And that is now the law, right? We got to be very, very careful about what we say, because that is not the law. That is an executive order, right? Executive order. Orders are not the law. Guys, consider the separation of powers. For those of you who may not understand this argument yet, and what we're bringing to the United States Supreme Court is this. We have three branches of government, three separate but equal branches of government, each with their own independent duties and responsibilities codified in the Constitution, a separation of powers, right? The first branch of government, Article 1, is the legislative branch. That is a legislative body of men who we delegate the power to go to Washington, D.C. and to make laws on our behalf, statutes on our behalf, right? We gave them the power to do it. We delegated that power, but we only delegated it to the legislative branch. No other branch of government can create law because all legislative power is vested in Congress of the United States. Legislative power means the power to legislate. Legislate means the law, right? So the first branch of government, representative branch of government that creates the law, they come together, they debate an issue, they determine, what is going to be the overarching laws that will then apply to everybody across the United States. That's why we have a federal government, because we create the laws by the central government and then we federate them out to each of the regional governments for application and administration. That's what a federal government means, is a federation where we create the laws by the central government and then we federate them out to each of the regional governments, right? That's why the Constitution itself says that this Constitution and the laws of the United States shall be the supreme law of the land. It's because the Constitution and the federal laws is supreme. All states must conform and comply with the federal law because there is no local option, as you might say today. The states don't have the sovereignty to be able to pick and choose which federal laws they want to follow or not follow, because the only thing that makes the union, the only thing that makes America is the American laws. So when the states fail to uphold them or refuse to comply with them, then we see a breakdown, fracturing, dissolution of nations such as we do today. Right? That's what's happening. So the first branch of government, the legislative branch, it legislates. All power to create law is vested in the Congress of the United States, just as Clause 1, Article 1 of the Constitution says. Now, remember, only people are bound to follow laws, right? Because the laws are the only thing that created adhesion, right, for us. The second branch of government is the executive branch. That's Article 2. The executive branch is there to enforce the laws. That's why the president's oath of office is that he will faithfully execute the laws of the United States, right? Faithfully execute. Because when you enforce a law, you execute the law. So the president of the United States is there to execute the law, which is enforce the law. His branch of government is enforcement. That's why all police, right? All FBI, the DOJ, the prosecutors, they all work for the executive branch, right? They're all agents of the executive officer. That's why they're enforcing the laws. That's why all these three-letter agencies are there to enforce the laws of the United States or enforce the laws of the state, is because those people work for the executive branch. They're enforcing law. They're part of the law, the enforcement branch. But what does the president create? The president does not create law because all legislative power is vested in the legislative branch. The people reserve the power to create law. The executive creates orders, right? Executive orders. But orders is not law, because the president, as a servant to the people, can't create something and order the people to do it. So what orders are is orders only affect those that can be ordered, those within the executive branch. So when the president writes an executive order, right, and says, okay, police, we're no longer going to arrest people or that are driving without a driver's license, that is an executive order directing his agents to decriminalize, not enforce a law, right? Because the law says that you have to have a driver's license. It says that you, at the state level, and I'm not arguing whether they do or don't. I would agree that they don't. I would agree that the Supreme Court of the United States has determined in a ruling, Thompson versus Smith, McCulloch versus, or not McCulloch versus Maryland, but Pennsylvania, Murdoch versus Pennsylvania. I would agree that the Supreme Court of the United States has made decisions that prevent the states from being able to enforce, such a law. But nonetheless, what he's done is he's created an order, and that executive order is then ordering people that work for him to decriminalize, to not obey the law, which is the right thing to do. It's the right thing to do. However, there's other ways that it needs to be done, and that brings us to the third branch of government here, which is the judicial branch. Okay, and the judicial branch, Article 3. They are there to administer the laws. They are the administrator. That's what they do. They administer the laws. Okay? Now, they don't make laws either. Judges don't make law. We know judges can't legislate, right? We know that. But when a judge creates a ruling, right, that's what the judicial branch creates, is judge-made rulings. They don't create law. So this whole concept of case law is absolutely contrary and foreign to our Constitution, because we did not delegate the power for the judicial branch to create law, to legislate. That's a separation of powers issue. So when the judicial branch creates a ruling and then calls it law, case law, well, that is unconstitutional. That is an overstepping of the separation of powers by a branch of government that is exceeding the power authority that the Constitution has statutorily conferred to them. So the third branch of government is the judicial branch, and the judicial branch makes rulings. But remember, the only people that have to obey rulings are people that are ruled over, right? Such as agents of the court. So, an attorney, being an administrative officer of the court, they have to obey the rulings, right? Because they are subject to the rulings. So your attorney believes that he has to follow the judge-made rulings because he's part of the court. He's subject to the rulings. But just like an executive order, we, the people, we don't have to follow orders because the president is a servant to us. His orders only affect those that he can order, which are agents of his branch of government, right? The people that are out enforcing the law. he can't create an order that tells the judiciary that they have to do something, right? The president has no power to order a judge to do something because of the separation of powers. So remember, the same thing applies to us. The president does not write an order that subjects us to that order, right? Because that would be a law, not an order. Because only laws are people subjected to. Now with the judiciary, just like with the executive branch, the judiciary can't create a ruling that directs the executive branch to obey, because only those that are subjected to the court would be subjected to the rulings. We, the people, are not subject to rulings. We are subject to the law. And that's why when rulings are contrary to the law, we can disregard them, right? Such as Hurtado versus California, where the Supreme Court of the United States in 1884 came out and said, state of California, you don't have to follow the Constitution of the United States of America. All of these attorneys believe, oh, well, that's what we have got to follow now, because they're subjected to rulings, because they're executive or they're administrative officers of the court. They are subject to the rulings of the court, but we, the people, are not. We, the people, once again, are subjected to the Constitution of the United States of America, the law. And if the ruling is contrary to the law, then we don't have to follow the ruling. And just remember, judges are tethered to positive law. What is positive law? Positive law is made by a body of men with the constituted authority to be able to create law. Congress, right? Congress has all legislative power. That's, again, Clause 1, Article 1. All legislative power is vested in Congress of the United States. So judges are tethered to positive law, right? Therefore, their rulings must be consistent with positive law. If they say, no, we're going to make a ruling that is contrary to the Constitution of the United States of America, what they're doing is they're saying that they have the power to legislate. And once again, they do not. That's a separation of powers issue. Judges cannot legislate. That's where we're at here, you guys. This is the issue. But now going back to this whole traveling thing, right? So the right to travel, a lot of people get it wrong. So for those of you here that are right to travel people, listen, it is not written in the Constitution that you have the right to travel. I would challenge anybody out here to go get a copy of the Constitution, read it, and tell me where it says that you have the right to travel, right? I would challenge you to do that, okay? Because it doesn't say anything anywhere. Not the 14th Amendment, not the First Amendment, not the Fifth Amendment, not anywhere within a body of the Constitution does it say anything about travel. So please don't come and say that the Constitution says that you have the right to travel. What happened was that in 1958, in the Thompson versus Smith case, the United States Supreme Court came out and said, you have the right to travel. It's protected by the Constitution of the United States of America. What happened there is they created a right. They incorporated a right. Okay, that's what that means. They said that the right exists for the people. It's not enumerated. It's not written. You can't find it within the Constitution because it's not there. But they said, the Supreme Court of the United States said it exists. You have the right to travel. And I would agree that you have the right to travel. But the primary reason why you have the right to travel is because government cannot interfere with your use of private property. That's the basis of it, right? The whole basis of the right to travel is that car is your car, right? And you have the right to be able to use your property without governmental interference. That is a basic fundamental principle of our Constitution. Government cannot interfere with our use of private property. That goes back to Dred Scott versus Sanford, where slaves are private property. Government can't interfere with the slaves. This is the basis of Thompson versus Smith, is that your vehicle is your vehicle. The problem is, once again, for those of you that already know this, is that when you register your vehicle with the corporation, that vehicle becomes a product of the corporation. And now it's operating under corporate rules. You have to step back from the contracts that exist. You entered into a contract and you place your vehicle into the corporation. Now your vehicle is not your property. It's corporate property. You guys understand these, right? But also Murdoch versus Smith, right? Where they said that you can't take a right, convert it to a privilege, charge a fee, and issue a license for it. That's absolutely true once again. But you know, the problem is that when the Supreme Court of the United States incorporates a right, right? When the Supreme Court incorporates right, in other words, when they find that a right exists that's not enumerated, then what has to happen is that Congress thus then must make a law to enforce the ruling. And this is what was never done, right? Congress did not take the ruling from the Supreme Court where the Supreme Court said there's a right that exists. We found that it exists, protected by the Constitution, and now the legislative branch must take that ruling and must create an enforcement statute to enforce the right. That was never done. The same thing can be said about the Roberts versus United States case. This is the case that I'm challenging, right, for the right to intimate association. In 1987, the United States Supreme Court came out in a case called Roberts versus United States, and they said that you have the right to have an intimate familial relationship with your child without governmental interference, and your child has the right to have an intimate familial relationship with you without governmental interference, right? So what they did was they created a right. They said that this exists. Yes, it is inherent. It's not written in the Constitution, but it exists. Okay, that is an incorporated right. It is not an enumerated right. Enumerated is written for all to see. That's already enforceable because it's already in the law. So for instance, this grand jury issue, that is enumerated. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That is enumerated within the Constitution. Therefore, a law exists. There exists an obligation, a limitation of power that government already has. Congress doesn't have to do anything because it's already there. It's already written. It already exists. It's already enumerated. Therefore, there's already enforcement statute that exists under Title 42, deprivation of rights under color of law, right? Any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. So on this indictment issue, it's easy because the law already exists. Government already has the restriction in place. Congress doesn't have to do anything because the law is already in place. And the moment that government breaks the law, then what they've done is unlawful. The product that they produce is unlawful. So it doesn't matter why a state created a statute that says we're not going to do what the Constitution says. All that matters is that they didn't do what the Constitution says. That's all that matters, right? So when you consider this, okay, your rights, once again, this is the doctrine of duties and rights. You guys, you need to understand where your rights come from. We're going to go back to the beginning here because I know Dave Jose's got some things to say about me and some of the things I've said in the past. So we're going to clear up a few things here. But the doctrine of duties and rights say that rights always derive from another's duty to act. Where there is no duty, there can be no right. So again, rights always derive from another's duty to act. Where there is no duty, there cannot be a right. Now, there are duties that exist that do not have a corresponding right, such as duty to God, duty to spouse, or duty to country, right? I have to obey God, but I don't get anything back in return for obedience to God. Therefore, I have a duty to obey God, but I don't have any rights that accompany that duty. That makes sense? The problem is that there are no rights that exist without a duty. So our Constitution of the United States of America, it derives from something known as the social compact theory. The social compact theory. And in the social compact theory, what happened was that in the uncivilized state of man, in the natural state of man, right? As a caveman, the rights that I have are undesirable. Okay. So in the natural state of man, only the strong survive. So in the natural state of man, you have the right to unalive someone. A caveman would unalive that person, right? Because he can. Because only the strong survive in the natural state of man. That's not a desirable right, right? But nonetheless, that is in the natural state of man, that's something we can do. In the natural state of man can steal from another man, right? Because only the strong survive. And you got to understand that when God created our rights, y'all want to say that God created the right and therefore it's protected by that. That's not true. Because if man did not have the right to unalive another man, then why would God have to create the commandment, thou shalt not kill, right? Thou shalt not unalive. You see, God knew that in the natural state of man, the right to unalive existed. So he created an obligation. Rights always derive from another's duty to act. A duty to act is an obligation. So God created a commandment and said, thou shalt not unalive. Now we have a duty, right? God created a duty. And in creating that duty, now we have the right to live, right? God always planned for us to be able to live, but in order for us to ensure that that exists, right, that that's maintained, we have to create a duty, and that's known as a law. So God created a law, and he said, thou shalt not kill. And as a result, we all have an obligation, a duty, because of the law to not kill someone. That's where it derives from. Now, the same thing can be said about our property. God doesn't want our property stolen. He wants our property to be ours, right? Thus, thou shalt not steal. He created a law that says, no, I want people to have their property. And therefore, he created a law that says, thou shalt not steal. And in doing so, now I have an obligation to not steal your property because the law exists that says, thou shalt not steal. This is what laws are. This is all that they are. A law is created to preserve a right. The problem is that absent a law, the right can't be violated. Okay? So if there's not a law in place that says you have the right to have an intimate familial relationship with your child without government interference, then I can't go to the government and say, government, my right to have a relationship with my child has been interfered with, because there is no law. There is no duty. The Supreme Court of the United States absolutely, in 1987, created the right, said that it exists. It exists. It's protected by the First Amendment and the 14th Amendment. It exists. They incorporated it. They found that it existed. But once again, does the Supreme Court of the United States have the power to create law? No, they don't. And the legislature knew that. So what if the Supreme Court says that the right exists? Until the legislator creates the law, there is nothing that binds the people to adherence to it. This is why we are fighting this in the manner in which we are. This is why I'm using the indictment by a grand jury issue in order to bring attention to these unenumerated rights, such as the right to travel, right? Such as the right to have an intimate familial relationship with your child. The legislature must create a law that says you have this right, and it must be written, it must be enumerated, because until the law exists, there is nothing that we can claim as a right that's been breached, because rights always derive from another's duty to act. Where there is no duty, there can be no right. And the Supreme Court of the United States has no power to create law. And so this is one of the things that I need you guys to be very, very cautious about. Is because when you go and you read a judge-made ruling, and then you say, oh, well, this is the law, and then you say, I have the right to travel, show me where in the law, it says that you have the right to travel. Because it doesn't, right? The Supreme Court of the United States says that it exists, you have that right, but until the law is created, there is no obligation for government. So your civil rights, they all derive from the Constitution of the United States of America. Remember, the main body of the Constitution, Articles 1 through 7, that creates the obligations of government, the duties of government. Everything that's in there are all the duties of government. So, for instance, Article 3, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. Is that a right, or is that a duty? Well, that's actually a duty, right? It doesn't say that you have the right to a trial by jury, because that's preserved within the Sixth Amendment, right? What it says is that no person can be tried for a crime with the exception of impeachment in any manner other than a trial by jury, because that's a duty. It's directing someone else on how they adjudicate a crime. So if your duties derive from another's duty to act, then the reason why your right to a trial by jury is unalienable, right? Can't be taken away, is because that judge has a duty codified in Article 3 that the only way you can adjudicate a crime other than impeachment is by a trial by jury, right? So when that judge says to you, do you want to give up your right to a trial by jury? His duty to ensure that you have a trial by jury comes before your right to give it up exists. Because in order for you to give up your right, he would have to breach his duty, because the duty comes before the right. The duty comes before the right. And there's a couple ways that you could look at this in order to understand this concept of the duty before the right. Our founders and forefathers, right, when they were creating the Constitution, they first created the main body of the Constitution, Articles 1 through 7. And again, Articles 1 through 7, they aren't rights. Nowhere within Articles 1 through 7 do you find a right. Those are all duties, right? And they're duties of government. Government must adhere to these duties. So Articles 1 through 7, now Article 4, I will agree, Article 4 alludes to the existence of a right, where it says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states, okay? That alludes to the existence of privileges and immunities. And again, you guys, when you talk about privileges and you tell me that privileges, are from government, that's not what that's talking about, you guys. The privileges came from we the people. We gave ourselves privileges because the Constitution creates privileges and immunities that was created by the people. Government doesn't give us those privileges because before government existed, we created the Constitution. So the privileges were granted by we the people. Our founders and forefathers wanted to guarantee certain privileges to you and certain immunities from prosecution or immunities from government, and therefore they preserved it into the Constitution, a contract. So the privileges aren't granted from government because the privileges existed through the contract that created the government. So government doesn't give us the privileges. Our founders, our forefathers, who we came from, the establishment of our nation, our privileges were granted by our founders. George Washington, Thomas Jefferson, James Madison, Alexander Hamilton, Benjamin Franklin, they created privileges for the people. And those privileges are codified in the Constitution. Government didn't create the privilege because before government was created, we had a constitution because it was by the Constitution that government was created. Okay? So don't tell me that government gives privileges, right? It was the people. We created the privileges and granted them to ourselves through the Constitution, which is a limitation of government, right? Government can't exceed the privileges that were granted to we the people. So please don't come with that silly argument, right? Because that's just silly. So when the Constitution says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states, what that's saying is that if you have a privilege in one state, another state can't deny you it, right? The privileges, the privileges and immunities of the United States, they apply equally amongst all members of the United States. One state cannot deny you from another state. And a great example is I think it's a McDougal case, 2010. It was a gay marriage couple. And I believe that they were in New York and they got married in New York. And the law allowed for them to be married lawfully within the state of New York. And so then they moved to Ohio. And when they got to Ohio, Ohio said, oh no, we don't recognize your marriage. We don't have same-sex marriage here, and they denied them the equal representation. Even though they had the right to do what they did, to exercise, and the privilege existed within the state of New York, when they moved to a different state, that privilege was denied. And thus they took it to the United States Supreme Court, and the Supreme Court said, no, Article 4, the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. So the fact that they were entitled to a certain privilege within the state of New York, when they moved to Ohio, Ohio had no lawful authority to deny them the same right, the same privilege that existed within the state of New York. And for those of you that are going through, thank you, Malibu. So for those of you who are going through, say, a criminal case where you're dealing with a drug offense, let me tell you, the state of Oregon and the state of Washington have decriminalized all drugs, right? Now that doesn't mean that they made them lawful, right? It's not lawful to have drugs on you. they decriminalize, which means that they are refusing to prosecute, which goes back to the president's in his executive order. So when the governor signs an executive order to say, don't prosecute anybody for traveling without a driver's license, what he's saying is I'm decriminalizing. Yes, the law exists, but we're not going to enforce the law. But my point is that is known as an immunity, right? Remember, privileges and immunities. Privileges are something we're able to have, right? If the law said that we could have drugs, then that would be a privilege. When the law says we're not going to prosecute you for having drugs, that's an immunity, okay? So we don't have the privilege to have drugs in our possession. But when the state of Oregon and the state of Washington creates an immunity that allows for non-prosecution of this law, what does Article 4 say? It says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. So if there's any state in the nation that decriminalized, that created an immunity from prosecution for a drug offense, then guess what? All states must comply with that same immunity. That's how federalism works. That's how this union works. Now, I can't challenge that. I'm giving this information to all of you because some of you could challenge this, and this is a 100% valid argument. And it's also protected by the 14th Amendment. That's extremely important to remember. Because when you deal with incorporation, you first must identify a breach of an obligation within the main body of the Constitution. I just gave it to you, Article 4. The citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. But now you have to go to the 14th Amendment, and you have to find a provision within the 14th Amendment that incorporates that to adheres with states. And that is the Privileges and Immunities Clause. No state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. Again, Article 4 says that if you have an immunity or a privilege in one state, another state can't deny you that privilege or immunity. Thus, through the 14th Amendment, you get incorporation through the Privileges and Immunities Clause. Guys, you can dislike the 14th Amendment all you want. I don't care. I'm not up for discussion. I'm not going to talk with you about it because that's bullshit, because we have to comply with the existing infrastructure. The way that they have the system established and set up today, we have to comply with that. And the way that they have it set up is they have the 14th Amendment. So we need to work within the existing confines of the existing structure of the system. So they have determined that the 14th Amendment is valid. I don't know if it's not valid or not. I honestly don't care. We win either way. Because if the 14th Amendment isn't valid, then in 1884, because remember, the 14th Amendment was ratified allegedly in 1868. Therefore, in 1884, when Hurtado versus California, in the absence of the indictment by a grand jury was argued, the Supreme Court relied upon the 14th Amendment to make that ruling. Therefore, if the 14th Amendment isn't valid, Hurtado is void. And thus, this issue has never been litigated. So we win either way. We win either way. But we have to proceed under certain presumptions. And those presumptions are they have the system in place in a certain way, all right? And we need to operate within the existing system and the structure that they have. If they want to come out and deem the 14th Amendment, not valid because it was never properly ratified, that's fine. They can head down that path. That's going to be much more of a nightmare for them than anything else, because that would mean that all of these acts of Congress ever since 1868 are void, because they are all relying upon the presumption that it is valid. So that would mean a pretty big headache for all these assholes up in DC and across the states, because they have continued to operate under the presumption of it being valid. Okay, but if they want to come back and say it wasn't properly ratified, that's fine. But they need to initiate that. Until they do, we are operating under the presumption that the 14th Amendment is valid because we win under the 14th Amendment. Because I'm relying upon the Privileges and Immunities Clause for this indictment by a grand jury issue. Remember, the 14th Amendment was adopted and ratified in 1868, immediately after the Civil War, right? And therefore, in 1888, Hurtado was the ruling that came out that said, yeah, the state of California doesn't do an indictment by a grand jury, therefore it's not required, right? So the state said, we're not going to do it. And they came out and said, yeah, the state California, you don't have to do it. What they did there was they made the state of California's law, right, their ruling, the foundation. And they removed the Fifth Amendment's requirement for the indictment by a grand jury from the Constitution. And all these states said, yeah, that sounds good and we're going to follow it. And ever since then, they've been following that. Ever since 1884. But the problem is that in 1868, We had law that was established and passed and ratified by the people of the United States that says no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens, right? Again, no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. The state of California created a law, right? And then directed all of their agents to enforce said law that violates the enumerated privileges and immunities of United States citizens. And we know that because in 2019, the United States Supreme Court came out in a ruling called Timbs versus Indiana. That's Timbs versus Indiana. This was a unanimous decision. 6 of the same justices that we're dealing with today made this ruling, which means we already have this decision. But what they said was the Supreme Court of the United States said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference because of their codification in the Constitution's text. In other words, if it is written in the text of the Constitution, if it's enumerated, it's the law. And every state must follow that law because the 14th Amendment says no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. In some states, you get the privilege of an indictment by a grand jury. In other states, you do not. Article 4 says that isn't possible, right? 14th Amendment says that isn't possible, and yet that's exactly what's happening. We have the states, right, such as Oklahoma, that has created its own law that says the prosecuting attorney can decide who gets an indictment by a grand jury and who does not. This is a public official that now gets to decide who has a constitutional right and who does not. And that is a law that is oppressive because oppression is defined as a law that treats one part of society differently than another, right? So the law itself is oppressive. Therefore, it is a violation of the 14th Amendment's Equal Protection Clause. No state shall create any law that does not provide equal protection of the law. Equal protection of the law means the law applies equally amongst all members of society. So when the state of Oklahoma creates a provision in its inferior constitution, I believe it's Article 2, Section 18 of its inferior constitution, and it says prosecuting attorney can decide who gets an indictment by grand jury and who does not. That is unconstitutional on its face under the Equal Protection Clause because that is a person in a position of authority deciding who has a constitutional right and who does not, and that's a violation of the Equal Protection Clause. Easy day, all right? So again, we win either way on this issue. But my point here is that when we deal with an incorporated right, remember, incorporated is the Supreme Court of the United States found that the right exists. It exists. And they found that you have the right to have an intimate relationship with your child. They found that that exists, and it does. God created you as a mother. God created you as a father. God created that child as a child. That is a creation of God. It's not a creation of the state. Right? This is what the Supreme Court was getting at, and it's 100% valid. But we do not have a law yet that says thou shalt not, interfere with this relationship. We have to get the law created. Just because the Supreme Court created the ruling doesn't mean that the duty exists. We must establish the duty. This is why most civil rights cases fail in procedural default. And this is why most attorneys aren't successful in civil rights cases, is because attorneys don't deal with fundamental law. I do. That's my area of expertise. I have a master's in substantive law. I know law enforcement. I know the enforcement of the law. This is the part that attorneys don't know, is that before you can claim that your rights have been violated, you first must show that someone had a duty and they breached that duty. Once you show that there is a duty that exists that has been breached, then you can claim that your rights have been violated. But you cannot claim that your rights have been violated until you first show that someone had a duty and they failed to fulfill the duty. They failed to obey it. Thus, they broke the law because the law creates the duty. So, like in this case, in the case of the indictment by a grand jury, the reason why I'm getting all of your affidavits is because that is a verifiable complaint from an actual victim who has had a crime committed against them. Someone in a position of authority broke the law. They breached the duty that is written in the Constitution of the United States of America. And by that breach of duty, right, now all I have to do is show that there was an obligation, that the law existed, and they broke the law. And once I show that the law exists, then by the breaking of the law, then that would mean that what they did was unlawful. Then you guys can claim that your rights have been violated. None of you can claim today that your right to a trial by grand jury has been violated because we haven't first shown that the Supreme Court of the United States has the duty, or these states have the duty codified in law, because the Supreme Court of the United States in 1884 said that law doesn't exist. So the Supreme Court of the United States, they amended the Constitution through a judicial ruling that they erroneously and unconstitutionally called law because they overstepped the separation of powers, decided they were going to legislate from the bench and amend the Constitution by eliminating the restriction that the Constitution has codified and enumerated in the Constitution of the United States of America. And they took their ruling that they unconstitutionally and erroneously called law and put it at the foundation, and then the states all said, well, we're going to follow this judge-made ruling. And we're going to create our own inferior laws that are contrary to the Constitution, and then we're going to direct our agents to go out and enforce that. Once again, 14th Amendment, no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. 1868, the 14th Amendment was established. 1884, the Supreme Court came out and said, yeah, state of California, you can create a law and enforce that law that's contrary to the Constitution of the United States. The timeline doesn't work, right? Because the law was already established that said that no state can create or enforce any law which shall abridge the privileges and immunities of United States citizens. And then the Supreme Court of the United States, 20 years later, came out and said, state of California, you can create a law and enforce it through your agents that abridges the privileges and immunities of United States citizens. This is why we're relying upon the 14th Amendment, because the 14th Amendment is our pathway to an easy win, especially when the Supreme Court came out in 2019 in a unanimous decision and said, yep, this right exists. So, but this is also the reason why, again, going back to the enumerated versus incorporated rights, you can't fight those two things the same way. So if we were to come to the Supreme Court of the United States tomorrow and we were to say, Supreme Court, you made the ruling in 1987 that says that we have the right to intimate association, that it was found to exist within the Constitution, and we challenge that, then this court, the Roberts Court, which, by the way, Chief Justice Robert is the best that there has ever been at fighting civil rights cases. He wrote the book on standing. Standing is what the court does. All courts do to prevent a case from coming forward. So they employ certain procedural tactics to prevent a case from proceeding. So they'll say, oh, it's not timely, right? Or they'll say, oh, it's the wrong venue. Or they'll say, oh, you got to go and exhaust state remedies. These are all tactics that the courts use to stand. And what they're trying to do is they're trying to dismiss the case through procedural defaults, because they know that if the case gets to the right court, that court has to make the right ruling. You see, all of these courts, the lower courts, the district court, the circuit court, they are all there to protect the Supreme Court of the United States. Because if these cases make it to the Supreme Court has to make the decision. And we know that because Chief Justice Roberts and Justice Thomas and Sotomayor and Gorsuch and Barrett and all the rest of the Alito and Kavanaugh, if a case comes to them that challenges the validity of Article 3, if they don't side with the Article 3, they lose their power. They lose their institution. If the people of the United States knew that the Supreme Court of the United States doesn't follow the Constitution because their rulings are contrary to the Constitution, right, because they are themselves unconstitutional or anti-Constitution, then the people wouldn't put up with that, right? This system only operates through honor. And absent honor, there is no system that exists anymore. So we can't fight an incorporated right. In other words, a right that was created by the Supreme Court. We can't fight that the same way that we would fight an enumerated right. Because if we brought this case to the Supreme Court today and relied upon Roberts versus United States of 1984 and said the court, the Rehnquist court, found in 1987 that the right to intimate association exists, then that court would say, we didn't find it. Where in the Constitution can we find that? They can't, because it's not written in law. And this is the problem, right? Because the moment that the Supreme Court incorporates, finds that a right exists, then the legislature must take immediate action to make the law exist so we can find it in the future. If we were to bring this case to the Supreme Court tomorrow, the Supreme Court would say, we didn't find it. We didn't find the right. We didn't find it anywhere in the law. So, one branch of government can say that the right exists. Even the executive branch could say that the right exists, right? Or in their case, they would say that the immunity exists. So the Supreme Court is saying that the privilege exists, but the executive branch is saying that the immunity exists. Because remember, difference in system. The judiciary says that they have rights. People have rights. They protect them. The executive branch, they say people have immunities. We protect them. We won't prosecute because there's an immunity that exists. But nonetheless, when those decisions are made, in order for them to apply to the people, we've got to have the legislative branch step up and do what they have to do to actually create it. And that's essential. And that has never been done. It's never been done for the right of intimate association. It's never been done for the right to travel and many, many others. All right. So the absence of the indictment by a grand jury. So you're absolutely right there, Kevin. I mean, absent the grand jury, the court has no jury. Actually, by the breaking of the law by the judge. So remember, the Constitution, Clause 1 of Amendment 5. This is what we're actually challenging. And here in a moment, I will explain once again how we're tying the family court issue in, how we're tying CPS in, because these two issues are absolutely interrelated. But give me 1 second here. So anytime that a judge breaks the law, you all know that judge loses subject matter jurisdiction. Subject matter jurisdiction. Okay? So the Constitution, Clause 1 of Amendment 5, it says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So, again, the Fifth Amendment is a little bit unique because the Fifth Amendment is not, it does create the rights, but it's known as prohibitory amendment, right? The Fifth Amendment is all the prohibitory amendment. And it's prohibitory because in it, what it does is it establishes the existence of a power, but it comes with a prohibitory act of government. Let me give you an example. In the Fifth Amendment says that no person shall be deprived of due process of the law. Okay? That doesn't say that you have the right to due process of the law, right? It doesn't. What it says is that hang on, that's not a good one. I want to step back because I want to step back. So there was just a case just last year that was argued at the Supreme Court of the United States. It had to do with government taking property without just compensation. I think it was a ranch in Texas. Some of you guys might know the case a little bit better than me, but it was interesting because the attorney or the advocate that was arguing on behalf of the petitioners, not the solicitor, right? Not government, but the other side. He came out and he started talking about these prohibitory amendment within the Fifth Amendment. And the one that they attached to was that no property shall be deprived of any person without just compensation. So that doesn't say that you have the right to have your property. It doesn't say that government has the right to take your property. What it says is that government has the power to take your property, but it comes with a prohibitory element, and that is you must be justly compensated. So the way that the Fifth Amendment works is that absent the prohibitory element of government, absent the prohibition, then the act of exercising power becomes unconstitutional. So government can take your property, right? You don't have the right to have your property when government takes it, But in order for government to take it, they have a prohibitory element, which is you must be justly compensated. The Fifth Amendment are all prohibitory elements. So the same thing can be said about the indictment by a grand jury. No person shall be held to answer per capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That doesn't say that you have the right to be free. That doesn't say government has the right to prosecute you. That says that government has the power to prosecute you as long as the prohibitory element is met. Indictment by a grand jury. Absent the indictment by a grand jury, absent the prohibitory element, the act of deprivation becomes unconstitutional, giving rise to injunctive relief. You guys can go after the government for the failure to comply with the prohibitory element. The whole Fifth Amendment is all that way. So remember what it says. No person shall be held to answer per capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Who is responsible for making the decision to hold someone over? The judge. The judge decides to hold someone over. So in other words, when the state of Oklahoma creates a provision in its inferior constitution that says prosecuting attorney, you can charge by information or indictment by your discretion, that's fine. That prosecuting attorney can bring the incorrect charging instrument because the prosecuting attorney does not have the constituted authority to make a decision to hold someone over. That decision is made by the judge. So if a prosecutor in Oklahoma brings the incorrect charging instrument by abusing their discretion to break the Constitution, it's up to the judge to make sure that he does not hold that person over without the indictment by a grand jury. You see, the law has gotten a little bit twisted for Oklahoma and a number of other states because you see, it's the executive branch that is bringing the incorrect charging instrument. But by bringing the incorrect charging instrument and abusing the discretionary authority that they supposedly have, they're now putting the judiciary and the judge in a very, very difficult place because the judge is now breaking the law by holding someone over without an indictment by a grand jury. So they've got this separation of powers issue where the prosecutor who works for the executive branch is abusing their discretion and bringing the incorrect charging instrument. And then a judge says, well, it looks good to me. I'm going to order this person to be held over without the indictment by a grand jury. Now the crime of deprivation of rights under color of law has occurred. It doesn't occur when the prosecutor brings the incorrect charging instrument. It doesn't occur under the inferior state statute. It occurs the moment that the judge orders someone to be held to answer for that offense. But the moment that that judge creates that order to hold someone over, the conspiracy to deprive of rights is instantly established. Instantly, by and between the judge and the prosecutor. Instantly. The prosecutor didn't commit the crime in violation of the Constitution because the Constitution says no person shall be held to answer. The crime was committed by the judge, but the moment that the judge commits that crime, now there is a conspiracy that exists by and between the prosecutor who brought the incorrect charging instrument and the judge who didn't make sure that the proper charging instrument was in place. Now you have the conspiracy to deprive rights. It's automatically established, but the crime, the initial base crime, the deprivation of rights under color of law, in Title 18 USC subsection 242 was committed by the judge. By the judge. Because the Constitution, the Clause 1 of Amendment 5 is a restriction against the judiciary. The reason why I want to bring that up is because the Supreme Court of the United States is the top of the judiciary. That's the highest judicial authority in the nation. And they came out and they said, yeah, we don't want an indictment by a grand jury. Why did they make that decision? Made that decision because their own people, their own workers were responsible for doing it. They weren't doing it. So the branch of government that made the determination that we're not going to have an indictment by a grand jury is the very branch of government that is obligated to adhere to it. right? It was the Supreme Court of the United States. It's the judiciary that must obey Clause 1 of Amendment 5. No wonder they don't want it to exist, because that would mean that their judges have been committing these crimes. You see, there's a conflict of interest for the Supreme Court of the United States to even make this ruling, because this is a obligation, right? It is a limitation of power that the Constitution has assigned to them, right? Ensuring that the judges have an indictment by a grand jury, and yet that branch of government is the one that made the ruling that said we're not going to do it. So the very branch of government that is bound to a limitation of power codified in the Constitution made a decision: we are not going to comply with that limitation of power. And then they hid it under the executive branch. They made everybody think that it's the executive branch, it's the prosecutors that's responsible for this, and that's not true. It's not true. It's always been the judiciary. So like Dunn, State versus Dunn. This is a state ruling that they rely upon on the absence of the indictment by a grand jury. State versus Dunn says that it's up to the prosecutor to decide whether to bring an indictment or an information. It's up to them. Well, yeah, it is up to them. A prosecutor can bring in information for non-infamous crime because the law allows for information for non-infamous crimes, misdemeanors. A prosecutor can charge by way of information for a misdemeanor, but they cannot charge for a felony by information. They can't, because the Constitution, because the law prevents that. And remember, what I'm talking about on all of these services that we're doing now, I'm trying to bring up the United States Circuit Court's two-part test that is used to determine abuse of discretion. Okay, so the United States Circuit Court has identified a two-part test used to determine an abuse of discretion. The first part says that did the judge rendering the decision, did he apply the incorrect test? You guys don't need to worry about that. But the second part of that test says that any erroneous view of the law is an automatic abuse of discretion. So again, any erroneous view of the law is an automatic abuse of discretion. And an erroneous view of the law would be that in the prosecutor's legal contemplation in deciding whether to follow a judge-made ruling or the Constitution of the United States of America, they decide to follow a judge-made ruling. That would be an obvious, erroneous view of the law. Because the judge-made ruling is the lowest form of law, and the Constitution is the highest form of law. So if I use my discretion to break the law, that is an abuse of discretion. And any erroneous view of the law is an automatic abuse of discretion. Everyone is prosecutors who decides that they're going to rely upon a state statute that permits them or directs them to break the Constitution of the United States of America. They have got an erroneous view of the law. Because in their legal contemplation, they believe that the state laws are more powerful than the Constitution of the United States of America, and that is not true. Thus, they have committed an abuse of discretion. And according to Blackstone, any public official who abuses any discretionary authority with which they're invested in law commits 3 crimes, automatically, 3 crimes. The first is perjury, because they promised to do something and they didn't do it, right? That's what perjury is. It's the effect of taking an oath. An oath is that you're promising to fulfill a future outcome. And when you fail to fulfill that future outcome, you've already implicitly invited punishment in the form of perjury should you fail to fulfill your promise. So when you promise to do what the Constitution says that you will do, and you fail to do so, you've already implicitly invited punishment. You've already said, I will be guilty of this crime should I fail to fulfill the promise. So every public official that abuses any discretionary authority with which they're invested in law commit that crime first. The second crime that they commit automatically is extortion. Okay? And extortion is to bring or to compel a result through illegal means. So what they're doing is they're bringing about a result, right? They're finding you guilty or they're having you arrested, but the way that they compel that result is through illegal means. They're breaking the law, right? That's why extortion is also the effect of an abuse of delegated authority. So when they abuse their discretionary authority with which they're invested in law, they commit extortion as well, automatic, because they're compelling a result through illegal means. They're abusing their discretion to break the law. You can never abuse your discretion to break the law, never, okay? And the third crime is official oppression. And official oppression is when they apply the law unequally against like members of society. So, earlier that day, that prosecuting attorney, or maybe at some point in time, that prosecutor decided the month before that he's going to give this person an indictment by a grand jury, but today he decided, okay, we're going to hold this person over without it, right? And so as a result, what they're doing is they're applying the law unequally against like members of society, and that's where, the violation of the 14th Amendment, the violation of Article 4 is where this all comes into play. So official oppression becomes a third crime, according to Blackstone, that every public official commits anytime that they abuse any discretionary authority with which they are invested in law. You can never use your discretion to break the law. Certainly not the Constitution. Okay? So Jessica just walked in, guys. You guys saw her. She's getting ready to get on to her 4:30. So if you guys want to get on that. So what we're doing, once again, is just as I said at the very beginning, you guys, how many times did Thomas Edison fail before he finally made the light bulb? 50,000 times, right? But he knew he was right. He believed in what he was doing, and he knew that it was going to work eventually, okay? I know that this is going to work. I know that I'm right. I 100%. The law is on our side. I know the law better than anybody else out there. I would challenge any attorney or judge on their knowledge of the Constitution any day, anytime, anywhere, okay? But I know that I'm right. And I know that this is going to work. And it may not seem like it just yet. I don't have control over certain things. What I do have control over is myself. And myself says that we're doing the right thing. Myself says that this is going to work. Myself says that we are going to be successful at this. I just can't tell you when. Okay? I just can't tell you when. So, but I know that we're right. I know that we're right on these issues, and I know that we're doing it the right way. Remember, I'm trying to do this in the least destructive manner possible, which kind of brings me to this other point here, and that is that it's well known that a peacemaker is capable of great violence and great destruction. But a peacemaker, what he does is he chooses peace, right? He chooses it because it's a choice. It's a choice that we can make. I know that I can destroy this whole system, right? But in destroying this whole system, I'm going to destroy this country. And I don't want to do that, right? What I want is I want those people in a position of authority to step up, be honorable, and do the right thing for the people of the United States and preserve this nation, right? That's what I want. And a lot of you guys point at me and you're like, oh, well, he said this was going to be done. And yeah, I have made that mistake numerous times. I have made that mistake thinking that I was going to find honor by a certain time. I thought for sure that we were going to be finished by June 6th. I thought for sure we were going to be finished by September 6th. And I made a lot of threats along the way, right? And eventually those threats could very well come to pass. But I'm not going to be the one to bring them to pass. This is a decision that they're going to have to make. I'm going to fight until the last second to do this in the least destructive, most peaceful manner possible. I don't want destruction. I want these judges and these public officials to step up and do the right thing. And I believe that we're going to get there. I believe it. I believe it. No one would be out here doing what I'm doing right now if they didn't believe in it, guys. I'm not making money. I'm living in a hotel and I'm driving every single day. You know, we were down in Harris County this week. I drove all the way 6 o'clock at night from Little Rock after serving in Pulaski County, Arkansas. Drove all the way down to Harris County so that I could speak for 1 minute the next morning. 1 minute. Guys, it doesn't do me any good to be in Harris County. It doesn't do me. I'm not from Harris County. I've never been impacted by the laws in Harris County, but you guys have. Right? You guys have. I'm not doing this for my good. I'm not driving around the country helping bring about this result for my good. It doesn't do me any good. I'm not in prison. I'm not under arrest. I don't have warrants. This does not do me any good. I have 3 master's degrees, 2 of which from the most expensive university in the United States. I don't have to be doing this. I'm doing this because I know I'm right and because I know I can do this, right? I know 9 years ago when I gave up everything, right? I knew back then that I was right. No one else believed me. No one else believed that the indictment was required. Everybody laughed at me. No one believed that the state could not be both accuser and judge because Article 3 says that the state cannot be both accuser and judge because if they are, then original jurisdiction resides at the Supreme Court of the United States. No one was arguing that. Either one of those. That came from me. You guys are hearing this spreading, and it came from me 9 years ago, right? I'm the one that brought in original jurisdiction. I'm the one that prepared the argument. I'm the one that worked it through the state courts, all the way through the circuit courts, and now sitting at the Supreme Court of the United States on a jurisdictional error. I did that. But part of doing that is that in order for us to actually make the Supreme Court of the United States hear the case, we got to bring attention to the issue, right? And so the only way that we can bring attention to this issue is by going out here and spending the time, traveling the country, meeting with people, providing these services over and over and over again so that people can actually hear this issue. You guys talk about me doing and saying the same thing in these city councils and county commissions. Guys, I'm not really doing this for you. I'm doing this for them. The message must remain the same. Slow and steady wins this race. Once you know the issue, right, then you don't deviate from the issue. I want the issue to come out. I want it to manifest. I want it to appear to everybody. I want everyone to understand this is the issue. The Supreme Court of the United States has no constituted authority to amend the Constitution of the United States through judicial ruling, and no state can create a law, substitute it for the guarantees of the Constitution, and go out and enforce it. Those are the 2 issues. And that's what we are bringing up. That's what Jessica's helping me with on this indictment issue. That's why we're working together, is because she brings 3 minutes in that I don't have, right? But in order to make the Supreme Court of the United States hear this case, someone has to go out here and someone has to take the time to believe that they're right, to believe that it's going to work, and to actually raise awareness on this issue. I want everybody to be aware of this issue. You know, we've got 208 people on Facebook right now. 115 people on Facebook right now. This time last year, I was lucky to have 5 people on. The information is spreading, right? It is. And for those people who say that this should have been done already, or that I haven't won the case, you're right. I don't have control over the outcome and the timing of the outcome. But no one would be out here doing what I'm doing unless they knew that they were right and they knew that they were going to win. We are going to win, but it's going to require all of you, helping to spread this information. I don't care about the critics and the cynics because those people don't count, right? The one that counts, just as Teddy Roosevelt said in his speech in Paris, right? It's not the critic who counts. The one that counts is the one that's in the arena. And that man that's in the arena, marred with blood and sweat and mud, he's going to fail. And he's going to fail again and again and again, right? But he's going to continue to do it. He's going to give himself to a greater cause because he believes in it, because it's worthy, right? It doesn't matter what the critics or cynics say. What matters is that person that's in the arena doing the work, right? Who is marred with blood and sweat and mud. But at the end of the day, that person, he either is going to be victorious, right? In which case he will know great victory, or he'll fail. But at least he'll fail daring greatly and expending himself into something that's more than just himself. And that's where I'm at. 9 years ago, I owned an engineering firm. I was making $870,000 a year working for government. And I absolutely hated myself. I hated who I was. I hated what I was doing. And I didn't understand why. I didn't understand why because I was on the wrong side. Right? And it wasn't until God woke me up and said, you're going to get on the side of the people. And we're not going to continue to protect government from the people. We're going to start protecting the people from the government. Right? I spent half of my life making millions of dollars, right? Using my education, everything I had to benefit myself. And in the blink of an eye and the swipe of a pen, it was gone. instantly, poof, all taken by a court and given to someone who divorced me, right? And as a result of that happening, right, it was the moment that I had nothing when I realized that something's got to be done about this. This is not consistent with the American principle. So the second half of my life, I just figured we're going to take my expertise, my talents, my degrees, my knowledge, and we're going to try to create something that's going to last. And that's what we're doing here, you guys. Something that's going to last is that Constitution for the United States of America. I want it back at its foundation. What it says is the truth, and no state, no court, no judge can refuse to obey what is written in it. Which brings me to, once again, let me finish with the peacemaker. So a peacemaker is capable of great violence. I know that if it came right down to it, we could tear this whole system down. So, because for 243 years, the people that were put into place to administer the law have never obeyed the law. And that is not an expert in the law, that's a criminal. Every single judge here in America is a criminal, right? Because they've never obeyed the law. And remember, ignorance of the law is no justification for having broken the law. So when a judge in the state of Washington breaks the law by holding someone over for an infamous crime without an indictment by a grand jury, there is no lawful justification for such act of deprivation in violation of the Constitution. They can't say, oh, well, the state told me to do it. No, because ignorance of the law is no justification for having broken the law. Every single one of these judges, whether they know it or not today, is violating the supreme law of the land, the Constitution of the United States. That is not an expert in the law. That is a criminal, because a criminal is defined as one who transgressed the law. Every single judge here in America is transgressing the law. There is absolutely no denying this truth. None. But the most peaceful way to address this is we've got to get them to, especially those that have the power. They are a superior force, right? With guns and all these other things. They would annihilate us if we went head to head against them. So what we have to do is we have to find some of them that are honorable. And I guarantee you that there are some. Let me give you some examples. I've been out to dinner with a couple governors. Those governors sat with me and they said, Mr. Downing, you're right. You're absolutely right. Constitution says it and we need to do it. I believe in what you're doing and I support you privately, but not publicly. Privately, but not publicly. Okay? All right? So they supported. These two governors, both of them said, we support you privately, but not publicly. I've been out to breakfast with United States representatives and a United States senator. They said, Mr. Downing, I believe in what you're doing. You're right. You're right. We got to do it. I support you privately, but not publicly. Right? Privately, but not publicly. I actually I went up to Minneapolis and I met with a sheriff's deputy, and I'm not going to say his name here, but I apologize on this story if you're listening. I'm not attacking you personally, but he took off the patch on his uniform. He gave it to me, and he said, I believe in what you're doing. You're doing the right thing. I support you privately, but not publicly. All right? So my point here is that, listen, you guys, there's a lot of people, a lot of sheep, a lot of cowards who believe in what I'm doing. Right? I've had attorneys say the same thing. You're right. You're absolutely right. But it'll never happen. It's too big. I support you privately, but not publicly. Those are sheep. And sheep are simply waiting for someone to lead them in a different direction. Right? So we have a lot of sheep. Right? We've had commissioners. We've had mayors. We've had city council members say to me, I would love to do this, but we don't know how to fix this. Right? We've had commissioners call us to come and serve them specifically because they want to try to make something happen, but they just don't know how to do it because no one's leading the way. So when you look at what we're doing here, many people would say that I'm failing, right? That I'm getting nowhere. I've done over 100 services and what has come from it, right? everything he's doing is just talk and all bluster, and that's not true. What we're doing is we're going out here and we're trying to find someone who's going to be that shepherd, right? Who's going to lead these sheep in the right direction. And we only need one. If one United States senator were to call me up and say, you know what, you're right. You're right. We got to follow the Constitution. And if they stepped out publicly, right, and held a press conference and said these states need to follow the Constitution, all of these sheep, right, that all are saying behind the scenes that they support me privately but not publicly, they're going to step out publicly too, because they're just waiting for one person to lead their way. We have to find that one person. And that's what Jessica and I are doing. We're out here. We're doing these services. We're bringing these notices. We're bringing, and honestly, like it's the pressure that's going to cause one of these people to step up. Because the truth is that what they're doing is treason. You guys all know it. It's all treason. Sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in an other than lawful manner. Sedition is the speaking or writing of words that changes the Constitution in an other than lawful manner. What has the Supreme Court of the United States done in 1884? They spoke and wrote words that causes disaffection to the Constitution intended to procure its alteration in an other than lawful manner. The one way to change the Constitution can be found within Article 5, and it has nothing to do with the judicial branch. The judicial branch has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. The state of Washington, its legislature in 1887, had no constituted authority to be able to speak or write words intended to amend the Constitution in another than lawful manner. That is an act of sedition. An act of sedition. And then that is a seditious law. But then when they direct someone to go out and obey that law and enforce it, that's an act of sedition. Now you've got an act of treason that comes into play. And we all know what the punishment for treason is. But you know what? We're not going to get these people to come across if we start coming after them for their treason. They know what they're doing, especially when I call it out, right? Criminal sanctions can come from what you're doing. It's up to you to decide what those criminal sanctions are, but I know what they are. So this is the thing. When you're notified, right, as a public official, when you're notified that you are a part of a criminal conspiracy intended to undermine the laws of the United States, such as Title 18, subsection 241, right? That's deprivation of rights under color of law and conspiracy to deprive rights. When two or more persons conspire with the purpose of depriving any person of any right secured by the Constitution commits that crime. That is the law of sedition by government officials. But the thing is that once you are informed, once you're notified, right? Because remember, what does the law say? Two or more persons conspire with the purpose of depriving any person of any rights secured by the Constitution commits that crime. The laws of criminal conspiracy for public officials says that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of commission of the same, neglects or refuses to do so, may be joined as defendants in the action. So we don't have to get a judge order to bring into the county commissioners meeting. I don't need to go to a court and get a clerk to sign something. No, all I got to do is put a notice on the record. All I got to do is inform those public officials right there of the existence of a breach of a constitutional obligation by agents that they pay. You see, this is the difference between administrative law and substantive law. Remember, I'm law enforcement. I'm substantive law. I do the first part. I build cases against criminals. When you deal with a criminal, I don't have to go into a courtroom in order to give them an official notice. All I got to do is go to them and say, hey, you're committing a crime. And if you continue one more time, now it's gone from negligence into willful criminal conduct because you've been made aware of your criminality and you've continued to do it despite being made aware. You see, that's the difference between an attorney and me, is that I don't operate within the parameters and the confines and limitations that a courtroom provides. All I got to do is go onto a public record, because I'm not an attorney. I don't perform attorney duties. Collecting affidavits from victims is a task traditionally done by law enforcement, not attorneys, right? Serving notices, right? Providing service is not a function ever performed by attorneys. It's a function performed by law enforcement, right? Because I'm law enforcement. So for those of you in Alabama that are talking about, potentially arresting Jessica and I for practicing law without a license, you better pull your head out of your ass, because we're not practicing anything. I don't walk in any courtroom, and I don't perform any roles that are traditionally performed by attorneys. I'm performing roles that are traditionally performed by law enforcement, because I'm law enforcement, as is Jessica supporting me. So, good luck with that. And we've already got attorneys that are standing by to go ahead and shut that down really quick. So if you come after us, Alabama or Florida, good luck, because even Justice Gorsuch just stated a couple weeks ago that the only way that you could prosecute someone for practicing without a law is if they are performing the duties or performing the roles traditionally done by attorneys. And collecting affidavits from victims is not a role that's traditionally performed by attorneys, nor is providing service. Service is always done by a service provider. So try again. Nonetheless, So when I walk into one of these city council meetings and I say to them, hey, this state has created a law. It's contrary to Constitution. And when you pay someone to go out and enforce that would be a crime in and of itself. These public officials, they have a choice right there. They can continue to do what they're doing, in which case now they're knowingly and willingly committing the crime that we notified them of, right? Or they can stop committing that crime. But when you as a public official are informed of the existence of a criminal conspiracy, two things must be done. You have to do two things. Let me tell you what those two things are. The first thing you have to do is you must notify the authorities of the crimes being committed. So we've served over 100 city councils and county commissioners all across this country. The moment that I inform them of these crimes, they have to notify the authorities of the crimes. They have to notify the authorities. But the authorities is not the state attorney general or their local police department, because according to the law, the only agency that can investigate the crime of deprivation of rights under code law is the FBI. That's the only law enforcement agency that has the authority to investigate such crime. So all of these city council members, all of these county commissioner members, in order to mitigate or comply with the first part of mitigating their culpability in this criminal conspiracy, the first thing they had to do was they had to call up the FBI and report these crimes being committed. It's the first thing they had to do. If they did not do that, then they are still a part of the criminal conspiracy according to the law. Once you're a member of a conspiracy, you must do two things to get out. The first is you must notify the authorities of the crimes being committed. If they did not, and I'm talking every single one of them had to call the FBI and report the crime being committed. Now, whether or not the FBI does something about it, well, who knows on that? But the fact that they did not call the proper agency with the authority to investigate that particular crime means that they're done. They're done. And then they continued to pay those public officials after being made aware that they've been paying for crimes to be committed. So none of them have done that. Now, the second thing that they must do, right, is they must notify their co-conspirators of their intent to no longer participate in the criminal conspiracy, but that must be done by an affirmative action. Okay? So again, they must notify their co-conspirators of their intent to no longer participate in the criminal conspiracy, but that must be done by affirmative action. So in other words, they must notify those that they're currently engaged in this conspiracy, but they must notify them that they're not going to participate in this shit anymore. So for instance, when I went to the Attorney General of the state of Vermont and I served her charity, right? And I served her with a notice letting her know that all your prosecutors all across the state are all, part of this criminal conspiracy to undermine the laws of the United States when they're charged by information on indictment. What she would have had to have done is first, she would have had to have notified the FBI, notified the authorities of the crimes. And then two, she would have had to notify all of her prosecutors that I'm no longer going to allow you to continue to do this because I'm notifying my co-conspirators of my intent to no longer participate. But it must be done by affirmative action. We must be able to see that she did something. And if she can't show us that she did something, then by her failure to take action, by the negligence, now, she is a part of the criminal conspiracy. And the fact that she continued to allow it to operate for almost a year now, despite being served with this notice and being made aware that her agents, the prosecuting attorneys and police officers all across the state of Vermont are undermining the laws of the United States by relying upon an inferior state statute that abridges their obligations codified in the Constitution. Well, she's now part of the criminal conspiracy, anyway, so a lot of people are asking, well, what's going to come from all this, right? Again, no one would be out here doing what I'm doing if they didn't believe that this was going to work. I'm trying to do this in the least destructive manner possible. I want to do this in the most peaceful way. I don't want anyone to lose their life in this. I think that the people have already suffered enough. I don't want the people to suffer anymore, right? This can go the hard way or this can go the easy way. The people of the United States deserve to have this be the easy way. And the easy way is that those people that are in a position of authority step up out of honor, out of respect, out of their duty, right? And obligations as a public official, as a leader of this nation to protect, defend, and preserve the one thing that their institution was created to do just that. And if we can't get them to step up and do that, then by their failure to do that, they will destroy this nation. The destruction is on their hands. It's not on our hands. I do not want to be responsible for destroying the United States of America. I'm here to preserve it, right? That's because a patriot is defined as one who loves and defends his country. And I'm proud to say that I'm as much a patriot as this nation has ever produced because I understand that if you love something, that destruction can never be an optional outcome for that is loved. I do not want to see destruction of this nation. I love this nation. I want to preserve it. Therefore, I'm doing this in the most peaceful manner possible. And some of you may disagree with what I'm doing, right? Some of you may say that this will never work. But you know what? I'm going to continue to do this in this way until the day I'm proven wrong or until the day that the people of the United States decide that they can no longer accept peace as an outcome, right? But I want to bring peace between this system and the people. I want to get them to reconcile. This is not the people's fault. This was the system's fault. The judiciary, for 243 years, has refused to recognize and enforce the body of laws that govern this nation. And as a result, the people are suffering every single day. Families are suffering. Children are suffering. Mothers and fathers are suffering. Prisoners are suffering. Elderly people are suffering. All these people are all suffering because the one thing that was designed to protect them and their property and their liberties is being abridged every single day by the very entity that was established to preserve it and defend it. Our government has lost its way. But if destruction is the plight that we're on, just as Abraham Lincoln said, if destruction be our plight, then it should come in our own hands. So is this going to work? I don't know. I believe it is because I do not believe that God makes fools. And so I believe that this is going to work. I believe that eventually here, any moment, we're going to find that honorable person that's going to step up and be a leader and going to lead all these sheep that are behind the scenes that believe in what I'm doing and agree with it, but just don't have the courage and the honor and the fortitude to step out on their own and do the right thing and to state that publicly they want to just support privately. And the problem with all of those people are, what do you think I'm going to say when I reach the end? When I reach the point to which that we win, because we're going to win. public officials. It's going to happen. I know you guys are banking on the chance that maybe this will all just be forgotten. Maybe it'll blow over. Maybe you can ignore it long enough that it'll just go away. Guys, if that's what you think is going to happen, you've never met someone like me, because that's not going to happen. That will never fucking happen. And right now, the cat's out of the bag. You know, there's enough people that are aware of this situation because I've taken the time to do this, you know, silently and build this silently, that there's more than enough people that if you take me out and you make a martyr out of me, you're only going to increase your opposition, right? Because there's enough people that are aware of these issues, that know this, and this is never, ever, ever, ever going to be put in the dark ever again. So you can just take that completely out of your thoughts, that maybe someday this will just be forgotten and it'll go away. It's never going to happen, government. It's never going to happen. You're the cause of this. You did this, not the people. You're going to fix this. And I don't care how big of a deal this is. It's not the people's fault. People did not do this. You did this. This was your ignorance, right? This was your greed and your dishonor. It's not the people. So, but all these public officials, they're all sitting back saying, maybe he won't be successful. You know, maybe this will blow over, and it's not going to happen. But if they reach a point, any one of them reaches a point where they say, you know what, this isn't going to blow over. This is going to happen. We're going to have to own up to this. Then what they're looking at, and they know this, they're looking at either one, they mitigate their culpability in the criminal conspiracy and they do something about this, in which case they step out publicly to save their own ass, preserve their own power, right? To prevent going to the gallows. And one of them feels the pressure just enough that they say, you know what, I'm going to be that first person to step across because, you know, this is going to happen. Eventually it's going to happen. Every single one of these judges, right, across the country know what I'm doing. Every single attorney general and their agents all know what I'm doing. I've already served them, you guys. You can't travel around the country and serve 47 state attorney generals, 47 state Supreme Courts with notices of criminal conspiracy to undermine the laws of the United States without them knowing who you are and what you're doing. You can't serve 100 United States senators without them knowing who you are and what you're doing. You can't go around and serve 100 city councils, county commissioners without them knowing what you're doing. They know who I am and they know exactly what I'm doing. And yet they're crickets. They're crickets. They're crickets because they can't argue the issue, because if they do, they're going to bring attention to the issue and they're going to lose. They all know that. That's why they're leaving me alone, because they know that if they make a martyr out of me, right, it's only going to increase their opposition. They know that they can't debate me on this issue. None of them can, because if they debate me on the issue, they know they're going to lose. There's no justification whatsoever for abridging the constitutional obligations. They know that they will lose in a debate with me, so they're ignoring me, right? So as a result, you guys got to remember, we have an incredible amount of power in the things that we do. When we speak the law, right, against those that are in power, they can't even speak back to us, because if they do, they're going to validate the issue, bring attention to the issue, and that means that they're going to lose the issue, right? So again, I can't say that this is going to work, but I can say that God's led me in this direction, and I believe wholeheartedly that it's the right thing to do. It's the most peaceful thing to do, and it does not result in additional potential lives lost. This is not a call to arms. This is not a go after your judge or your prosecutor or any public official. This is, I'm going to stand with the law, right? And I can't prevent you, public official, from exercising your power. But what I can sure in the hell do is I can show you what the law states, and that you guys are clearly operating outside of that law. And as a result, what you're doing is unlawful. And you, public official, you got a choice. You can either return to established rule of law and obey it, or two, you'll be known as a criminal, because a criminal is simply one who transgressed the law. And criminals aren't leaders. Criminals don't get to have valid decisions and rulings put into place. Criminals don't get to send other criminals to prison. So as of this moment, government, everything that you're doing is unlawful. Everything that you're doing is producing a completely void outcome because of your own unlawfulness. So if I were you, I would take a look at the situation and I would say, you know what? Nothing we do is valid anyway. Right? None of these rulings or orders, and none of these prisoners, none of these convictions are valid. None of these removal of children is valid, right? None of it's valid, because if you have to break the law to make that happen, right, then what you produced is unlawful, because by your breach of the law, by your unlawful act, what you produce is unlawful, no matter what. And there isn't a single person that's been convicted of a crime here in America lawfully because you, Supreme Court of the United States, your institution, under those despicable predecessors that came before you, that you tell us we must call honorable, who broke the law and who put into place a ruling that removed the limitations of power that the judiciary had, right? Your own institution did that. And then your own institution, the highest court in the land, directed all the courts in the country that they don't have to follow the Constitution. You did that, Supreme Court. That was your fault. That's on you, right? So as a result, every single court in the country is operating under fraud introduced by the Supreme Court of the United States in 1884, right? And we all know that fraud vitiates any decision or action of a court. When the Supreme Court of the United States introduced the fraud into the system and directed all the courts within the purview of the Supreme Court of the United States, every single court in the country, that you don't have to follow the Constitution, you don't have to give criminal defendants the rights that are enumerated in the Constitution of the United States, by that fraud being introduced by the Supreme Court in 1884, nothing that any court in the country does is valid because it all derives from the fraud that's introduced by the highest court in the land. So Supreme Court, this is on you. Like, you have to step up and you have to fix this, because nothing that any court in this country does is valid because of the fraud that your institution put into place, right? That all the courts are still operating under the fraud. And we all know that until the fraud is removed, that fraud vitiates any action of any court, period. Supreme Court is the one that has to make this decision. So for all of you in these affidavits, the affidavits that I have, it's not for you to go and file with your case, right? You're not going to get anywhere with your local state judge by taking the affidavit that I have and going and filing it with your judge and saying, well, Judge, I didn't get an indictment, it's all void and go away. That's not the purpose of those affidavits. The purpose of those affidavits are me to have the power to go to the highest court in the land and make the highest court in the land obey the law. And when the highest court in the land obeys the law, then that means that the lowest courts in the land will automatically have to obey the law also. But as long as the highest court in the land is not obeying the law, then don't expect the lowest courts to obey it either. They're being permitted through the fraud that was introduced by the Supreme Court of the United States in 1884. They're being permitted to do these things. And until the highest court in the land, until I get them to own up to their crimes, the lowest court in the land is going to continue to commit these crimes. They're going to. That's why what you guys are doing is you guys are giving me those affidavits. You're sending them to me in North Carolina to Justin Carey's address, so I can have the power of millions and millions of people that have had these crimes committed against them. I can go in as a law enforcement expert, as a substantive law expert, not as an attorney, but as a law enforcement expert, to go and have criminals held accountable for the crimes that they've committed against all of you, right? Because before you can claim that your right has been violated, we first must show that someone had a duty and they breached that duty. That's what I do. That's law enforcement. That's substantive law. So I am going through law enforcement, right? Through the substantive law, I am going to establish that government had a duty. They breached that duty, and in doing so, that gives rise to your right. The existence of your right gives rise to injunctive relief. You guys can then claim that your rights have been violated because government had a duty to ensure that there was an indictment by a grand jury prior to being held over for those offenses. Okay? All right. I am, let me look right here. Okay. So there's been a couple of executive orders here recently that were real interesting. One is, and I'm only bringing this up because they were interesting to me. And this isn't something that I'm pursuing. This has nothing to do with any litigation that we're working, but maybe the things I'm about to say to you maybe might help you think about ways that you might be able to approach, some of your cases. Okay. So we all know that the Chevron ruling was overruled last year, right? Chevron. So June 29th of last year, 2024, Chevron deference rule was technically overruled. And the Chevron deference rule was if the law is ambiguous, right? If it's not clear, if it's ambiguous to the executive officers, because remember, the president is part of the executive branch. Executive officers would be those that are enforcing the law. So if the CIA enforcing the law, or the FBI enforcing the law, or the Attorney General enforcing the law, if they weren't clear on what the law meant, right, or what it was saying, and it was ambiguous, then what they could do is they could write policy. They could write orders that would clarify the law, right? So the attorney generals were typically saying, oh yeah, this isn't clear, so we're going to write our own policy, our own orders, and then order our people to obey that. And so this was challenged. And ultimately, the question is does the executive branch have the constituted authority to be able to amend the Constitution of the United States of America? The answer is no. Because just like I said in the very beginning, the executive branch creates orders. Orders can only affect those that are being ordered. People are not affected by orders because only law affects the people. That's it. So when the Supreme Court came out and they said, hey, executive branch, you don't have the power or the authority to do whatever you want if you're not clear what the law states or its intended purpose, or if it is ambiguous to you, then you must go back to the branch of government that has the constituted authority to be able to amend it. Because if you yourself, executive officer, decide to amend the law through an order or policy, that would be unconstitutional because the executive branch has no authority, no constituted authority to legislate, right? Just like the judicial branch has no constituted authority to legislate. So this was what was decided back a year ago. Now remember, Chevron dealt with the executive branch. Executive branch, you don't have the authority to create law. Therefore, if you're not clear, you got to go to the legislative branch to get clarification from them, because otherwise what you're doing is you're amending the law by a branch of government that does not have the authority to do it. Remember, I'm working, my litigation, what I'm currently working on is the other half. I'm working on the judiciary, right? Because I'm saying the judiciary doesn't have the authority to make law either. So Chevron deals with the first half of getting rid of all the policy. None of that policy is law, right? Because the executive branch doesn't get to create law, they create policy. And policy is not law. Therefore, everything they were doing was unlawful, was without law, because it was policy. So Chevron removes the first part. I'm working on removing the second part. What I'm doing is I'm fighting the judiciary. And I'm saying all your rulings is not law. Case law is not law because judges can't legislate. So I'm doing the inverse of Chevron. Chevron was last year. We're working on the second half. And when we get rid of this, then what will happen is that the Constitution isn't the foundation. Because today, under Chevron, the executive officer could write policy and go out and enforce it in violation of the Constitution. Under the current, common law practice, the judiciary, such as in 1884 with Hurtado, the Supreme Court of the United States could write a ruling, create a ruling, call it law that changes the Constitution, right? That doesn't mean, that means that the Constitution is not the foundation. That means that judge-made rulings is the foundation. That means that executive orders are the foundation, policy is the foundation, not the Constitution. So if we want the Constitution to be back at the foundation, at the bottom, we had to, first remove all the bullshit that the executive branch created. That's what Chevron did. And now the other half is over here. We got to get rid of all of the bullshit that the judiciary created. And once we do that, then we'll see the Constitution fall back into its place, the foundation, and then we will be able to live consistent with the rule of law and not be, relying upon bullshit that was created by the administration or bullshit that was created by judges, because they don't have the power to legislate. Only people do. But they are bound to the limitations of power that the legislation of the law creates, limiting them in their exercise of power. Okay, so we're dealing with the second half. But my point here is that again, Chevron was all about that the executive branch does not have the authority to legislate. Well, this last week, President Trump actually signed an executive order that changed marijuana from a Schedule 1 drug down to a Schedule 3 drug, right? Essentially decriminalizing it, essentially creating an immunity to it. So here's the problem that I have with that. I'm okay with it. I don't smoke marijuana, and I hate the smell of marijuana. I absolutely hate it, guys. I walk around town and I smell it. It makes me sick. But nonetheless, so the problem that I have with that is that if the president has the power to decriminalize drugs or to make immune drugs, then it would seem to me like the drug laws are nothing more than policy to begin with, right? Doesn't that seem that way to you? Because if it were law, then the executive branch couldn't change the law through an order. He couldn't change the drugs from Schedule 1 to Schedule 3, thus decriminalizing it, making it immune. That means that the drug enforcement laws are actually policy, which would be consistent with the time frame because the drug enforcement laws were in the 80s, right, which is around the time of the establishment of the Chevron ruling and Chevron doctrine and all the rest. So you guys should look into that. Right? You guys should look into that, because if the president is able to make immune the marijuana, then that means that that's not law. That means that that's policy. The other thing is that the president signed another executive order that says that after the first year, that they are not to arrest people or whatever that are driving without a license or suspended license or whatever. They're traveling. And once again, if the president is able to do that, then that is actually policy, right? That's actually policy. That's not a law. Just as I said in the very beginning, right? That the right to travel was found to exist by the Supreme Court of the United States, but it's not written in law. Thus, there is a policy created by the executive branch that says arrest people that are traveling without a license, right? Because they got to have a license. It's not law. It's policy. So if the president is able to sign an executive order that changes the things that happen, the criminality that happens, then that's not law. That's actually policy. And that would be void under the Chevron ruling. So I think it's a good thing. I do. I think it's a good thing. I would agree with the right to travel. I would agree with the right to use our property. It's just what I'm saying is that there's a whole bunch of people that they're bringing up the right to travel. And I just wanted to bring that to their attention because I know a lot of people are currently litigating those types of cases. Think about that. Think about what I just said, that the president signed an order that created policy that says we're not going to criminalize anymore, which means that there is no law that exists. That's the whole point I'm saying, is that as you guys are dealing with these right to travel cases, think about policy versus law. And if the president has the power to write an order, then that means that it is not a law, it's policy, right? And you guys can attack it from the policy perspective for your right to travel cases. All right. Another thing is that good. So another thing is that some people have been talking to me about serving county commissioners and city councils with the notice for right to travel. And I think that's a great idea. I do, to bring attention to the issue, and I would be happy to help write a script for you guys. If you guys want to go into your local city council, county commissioner and serve them with the notice. The problem is that, and this is one of the issues that Jessica and I have, is that, we have to be very, very careful. Because when we start talking about the rulings from the Supreme Court and that, the legislative branch are bound to obey those rulings, there is a duty there. So when you walk into a city council and a county commission, you can say to them, you guys have to obey the ruling by creating a law, because they said that the right exists. Therefore, you have to create the law to coincide with it. This is the duties and responsibilities. So the legislative branch is actually accountable to the rulings created by the Supreme Court, but the executive branch is not. Police officers don't have to obey the ruling because there's no order limiting the exercise of the power. The law or the ruling, would come from the court. The law would come from the legislative branch, which would then bind the executive branch to adherence to it. So as long as you're not going to police officers and law enforcement saying, hey, I have this right that exists, because they're going to say, no, you don't, because we don't have a duty to not infringe on the right. Therefore, you can't claim that you have a right until we first have a duty. So you can't go to police and say, hey, we have this right. And you can't really say in one of these services, in a city council or county commissioner, you can't say to them, hey, I have this right that's being abridged also, because nowhere in the Constitution does it say it. So the script would be slightly different. And this is why, what Jessica's doing on the right of intimate association with the family, it's a very, very difficult thing to go down that path, right? It's a very difficult thing. So, because once again, it doesn't exist in the Constitution. But when we start emphasizing the fact that there's a ruling, we cannot call that ruling law, because otherwise we undermine the argument that we have for the Hurtado case, right? In the absence of the indictment by a grand jury. We either need to stick with the separation of powers, and thus executive branch and judicial branch does not have the power to legislate. Therefore, that ruling is not law, but it is a ruling from the highest court in the land. Therefore, courts, you all got to follow it. You just got to be careful. So I would agree that if you guys want to go out and start serving some of these city councils, county commissioners, I think that's a great idea to bring some attention to the issue. I would be happy to help you guys with that service. If that's something you want to do, we're not going to detract much from the Hurtado stuff, but I'm going to say that's a good idea. It's a great idea, actually, to bring attention to this issue, because once again, when the Supreme Court of the United States created or incorporated the right, says that you have the right to travel, right? It's not in the Constitution. You cannot find it anywhere in the Constitution because it's not there, but it was created and found to exist by the Supreme Court's ruling. Then what we got to do is we got to bring attention to the issue to where legislation has to be created to protect the right. Because without a law protecting the right, you can't claim that your right has been violated. So a lot of you guys that they're like doing appeals or whatever else, typically the response that you get from your court is petitioner failed to state a claim upon which relief can be granted. That is code word for there is no law that the petitioner brought forward, therefore we can't grant relief. Right? Petitioner failed to state a claim upon which relief can be granted. That is code word for you said you had a right, but there is no law that exists to protect your right. So if you're getting responses back from courts, appellate courts or whatever else, that says petitioner failed to state a claim upon which relief can be granted, all that they're saying is show me the law that you're claiming you have a right on. And if you can't show me a law, then there is no right that can be violated, because your right derives from another's duty to act. And the duty to act derives from the law. If there is not a law limiting the exercise of power, then there cannot be a right that's been violated. So before you can claim that your right has been violated, you first must show that someone had a duty, they breached that duty, thus breaking the law, and as a result, now you can claim that your right has been violated. But you first have to show that a law exists. And that's why these affidavits, just as I said, these affidavits I'm using to show that there is a law that exists. It's written right here. Constitution says there must be an indictment by a grand jury. And oh, by the way, here's 2.2 million people who've had these crimes committed against them. I don't know how long it's going to take to get there, but we're going to get there. All right. So, if you guys want to get on with Jessica, it looks like it's about an hour in. What she does every single week is she talks about what we're doing on the county commissioner side. So Jessica joined me about last April, and we started working together last April. She's amazing, but I needed help because I wasn't getting any attention. I've been at this for 9 years. I've done lots and lots of services, serving city council or attorney generals and senators and Supreme Courts. I did a ton of work before, and I wasn't really getting anywhere. And all of a sudden, she came in, and we just traveled together. I was doing all the services, but she traveled with me for probably the first 7 months, just watching what I was doing, listening to the things I was saying before she finally stepped up. Her first service was in Fort Wayne, Fort Wayne, Indiana. So prior to that, I had already done the attorney generals and Supreme Courts and done all these services with those officials, but I wasn't getting any traction, wasn't really getting noticed. And then I had already started planning to go into the city councils, county commissions. I'd already done Fairfax and Jefferson County and Douglas County and City of Columbus and a number of them. And then she's like, you know what? I'm ready to go. And so that's when we got into Fort Wayne, and she did her first service there, and it's just been the two of us ever since. So, she for a long time was doing the first half of the script, and then I was coming in with the second half. But then she wanted to go into the family side, and it's extremely important. I always knew that we were going to be doing family stuff. I just wasn't sure how it was going to work. So she's providing that second half of the work. So remember, one of the reasons why I'm able to that's pretty stupid. You say my wife will be smacked around by a Muslim man soon? Yeah, dude, you're a real winner. Good luck with life. So so one of the reasons why I'm able to do this on your behalf is because in order to challenge the unconstitutionality of a law, you must first show that, or you must be directly impacted by the law. Sorry, guys. Let me go ahead and report this and get this guy blocked. Yeah. All right. You start threatening to smack around Jessica, and you're going to be blocked here. And I'm going to report all of your comments. So, yeah. 55 Trey wants to smack around Jessica. Scumbag. All right. So in order to challenge the unconstitutionality of law, you have to be directly impacted by the law in question. So I needed to be directly impacted by the law in question, the Hurtado law, in order to be able to challenge it. And I knew that long time ago, you guys. I knew it. I mean, for those of you that know my history, you know that I actually fell so that I could build the case to be able to win it. That's what I did. You guys can believe that or not. It's irrelevant of whether you do or you don't. But I did that for that reason. Because in order to challenge the unconstitutionality of law, you must be directly impacted by the law in question. That's why I'm able to litigate this on your behalf, because I was directly impacted by the law. Therefore, I can litigate on behalf of the entire group. Because if one case wins, all cases win. I built this case to do just that. I mean, I've been building it for years, 9 years, by God's hand, divine hand. It wasn't my intelligence. It was definitely something much more powerful behind me that was leading the way. But that being said, I knew that family court was going to be a part of this. But the problem was that I have never been impacted by family court either, right? Jessica has. So Jessica's bringing in, and she has the amazing case as well, and she's going to be able to litigate that case on behalf of the large group of people that have had CPS and family court issues. I can't do that because I was not directly impacted by the law in question, but she has. So together, between her and I, she's got family court, I've got criminal court, and we both have the power to litigate because the litigator is one who litigates on behalf of others, right? Or litigates a case. We can litigate our own case. And it just so happens if we put everybody into the same procedural situation as our case, then that means that we can litigate on behalf of the entire group, right? And that's what we're working toward here. So she can do this on her own, just like I can do this on my own. But in order to get to that point, we've got to bring a lot of attention to this issue. So all right, I need to finish up here and then go check on Jessica and see what she needs to talk about over there. If you guys want, you can go to her Zoom. It would be on justicewithoutlimits.org. So we have two websites right now. We have https://www.tanawah.com. That's TANAWAH.com. That's my website. It's a little bit clunky and difficult, but there's a lot of good information for you guys out there. or you can go to www.justicewithoutlimits.org. That's Jessica's website. From there, you can download the affidavits that I need for the absence of the indictment by a grand jury, or the affidavits that I need for the interference with the familial unit, also with the instruction sheets, and you can send them to the North Carolina post office box. That's the only one we have. So you send them off to North Carolina post office box. You can also download the script to read if you guys want to get out and serve your local city council or county commission. You guys are inspired by the work that we're doing. You want to be a part of it. You want to help with it. You can download the script. All right. But remember, we're moving in on the incorporated or the enumerated right, the indictment by a grand jury. That's why you have to, at a minimum, that has to be read. Right? Because that is the one that's written in the Constitution. It's the one that can be found, and it's the one that every single state is abridging. Okay, every single state across the country is abridging it under a judicial ruling. So we're using the indictment by a grand jury in the absence thereof as the basis to get into the court to argue. But when we get there, Jessica's got a great argument that she'll be bringing up on the family court, how we're tying these two together. Some of you know, some of you don't know. I don't feel like talking about it right now. I've been talking for a little bit too long now. But we will be litigating both these issues together. But to get into the court, we have to use the enumerated right, the one that's actually written, the one that can be found to exist. We can't use the incorporated right, okay? So you can go out to Just Without Limits. There is the script that you would read. It's a 2-page script. It takes about 2 minutes and 30 seconds to read through it. There's also a notice there. It's a 6-page notice. That notice is provided to the clerk of the county or the clerk of the city, depending on which service you guys do. But you would read the script, and then at the end it says, I got a notice to provide. You give it to them. That puts them on notice, all of them. Now, one of the things that's important here is that it's not up to you guys to make sure that they understand what you're saying, right? It's not up to you guys. It's not up to you guys to make sure that they comprehend what was stated in the notice. They probably don't understand what we're saying. They probably don't. But just because they don't understand doesn't make them immune or not liable for the crimes they commit. We put it on the record. If you don't understand public official, then you have to go out and figure out what we're talking about, right? And if you don't, that does not mitigate your culpability. It does not make you immune. Once we put this information on the public record, it doesn't matter how fast I speak, right? It doesn't matter, whether or not they comprehend what I'm saying. What matters is it was on the record, and if you continue to proceed in the criminal conditions that exist today after being made aware of those criminal conditions, now you're a criminal. And now you're knowingly, now we've established mens rea. You're knowingly and willingly continuing to commit these crimes, right? I don't need a judge-made note, order or notice or whatever to put them on record. All I need to do is I've informed you of this existence of this criminality, and you chose to continue to do it. And now I can proceed criminal charges against you because mens rea has been established the moment that put on the record. So it doesn't matter. It doesn't matter so much whether you read it perfect, right? Because the 6-page notice is clear. It explains everything in it. But if you read the script, you put it on the record, you submit the notice, you don't got to worry about whether or not they comprehend it, right? You don't got to watch these videos and say, oh, well, they clearly don't understand what they're saying. I don't care. It doesn't matter whether they understand what I'm saying or not. What matters is we put it on the public record. It's now of a public record, and now they have a duty to take action as lawfully required. Otherwise, they are enjoined within the criminal conspiracy, and they can be added as defendants in the action that we ultimately bring. So you can download the script to read, as well as also the notice to provide. And Jessica's providing the training right now on Zoom. I believe on the first page there is a national database for information. We're not collecting information to share it with anybody. We're doing it because we're traveling the country and we need to be able to get information out quickly. When we're coming to your area, whatever it might be, we're not trying to get your email address or your phone number so we can share it with someone. We're doing it because this is what we're doing. And we need to be able to have quick communication with different people. So, hopefully you guys are willing to go out there, fill that out so we can have that information to be able to share with you. It's not being shared with anyone else. But the Zoom information is there, and you can go out there for that. What else? There's still a lot of scammers pretending to be Jessica and I, all right? And they're scamming. They've made tens of thousands of dollars easily off of you guys. I mean, lots and lots of money. We've seen at least 4 people that have paid $2,500 to this piece of shit, and claiming to be us. And guys, I can't control that. Okay. One thing that has to happen is that if you guys have been scammed by someone saying they are me or Jessica, I would ask you to please go to your state attorney general, to your consumer protection division, and report the crime, right? Even if that brings heat down on me, I don't care, right? What I care about is what they're doing to all of you, right? They're stealing from all of you in my name, pretending to be me, and then it's putting a bad name on me and Jessica. And you guys, a number of people are, putting out videos saying that we're scamming and stealing from all of you. We're not, right? We don't make money. I've never had $2,500 donated to me ever. And yet we have at least 4. We got a message the other day from someone that they knew us, so they communicated with us normally, so they knew that they were talking with someone that was fraud. But this fraud, actually, we got screenshots of their communication, and this guy came back. He's like, hey, $40,000 and I'll take on your case, and I'll come to your city and do your case for you. What that tells me is that this asshole's actually getting that kind of money, right? I mean, if he's willing to ask for $40,000, he's actually getting a lot of money. I don't want that, right? I have never, and I will never offer to come to your city and fight your case because I'm not an attorney. I don't practice law, right? Neither does Jessica. We don't do that. The case that we're building is going to help all of you. The jurisdictional issue, can a state be both accuser and judge in the same cause? No, it can't. If I can successfully argue that, then that means that all the state prisoners, right, all the criminal matters, void. That means all of the CPS issues, void, because the state can't be both accuser and judge in the same cause. That helps all of you. Therefore, we don't got to go and fight an individual case. All we got to do is continue to push into the main court, into the Supreme Court. And when we get into that court, because we brought enough attention to the issue, once we brought enough attention to the issue and we're in the Supreme Court and I successfully argue this issue, which I can, then that means that once we get that ruling, it will then render void all of the lower rulings. You will get the help that you need from the case that we have. So we don't need to come and fight individual cases. I need you guys to get behind me and help me, right? I need you guys to push me, bring attention to this issue, get us into the Supreme Court, and let's get this argued. So if you guys do want to donate, right? If you guys do want to donate, we always need donations. We don't do this. I don't do this for money. Right? I haven't done this for money for years because prisoners and children that are being taken from their families, they don't have money. So I can't expect them to give me something that they don't have. But if you guys want to help see us be successful and continue to move forward, we operate only on donation. You guys know that. But this is the We Shall Be Free tour. We shall be free tour. Therefore, Cash App, Chime, Venmo, PayPal, the ways to donate to us is We Shall Be Free. There's no other way. If someone messages you asking you for an Apple card because we're stuck on the side of the road, they're full of shit. Because the only way that you can donate to us is We Shall Be Free. And make sure that you type in the right We Shall Be Free, because now there's fake accounts with 3 E's on the free. There's fake accounts with a hyphen at the end of the free, right? These are not us. All 4 of them is We Shall Be Free. That's WESHALLBEFREE. When I spell stuff out, I spell it proper. There's no slang in it, all right? We Shall Be Free tour receives money from We Shall Be Free tag on Cash App, Chime, Venmo, or PayPal. And if you guys got any questions, if you're not sure the right account, go to justicewithoutlimits.org and the donation points are there. So if you're not sure if it's the right account, go to the website and confirm it from the website, okay? But please, if someone messages you asking for money, it's not coming from us. I have never, and I will never do that, nor will Jessica, because we are not solicitors, right? We're not attorneys. We're doing this because it's the right thing to do, but we can't get paid to do these things because that would mean that we were soliciting, right? That we were practicing. We're not practicing, all right? We're not. And the work that we're doing, once again, Alabama and Florida, if you want to get a little frisky on this, this is not work that's performed traditionally by attorneys. Therefore, there is no grounds to accuse us of practicing law. And you guys want to come after us for what we're doing right now. All I can say is good luck. All I can say is good luck. All right. So please donate. Last week we had, it wasn't a really busy week. We did Pulaski County, Arkansas. We tried to get into Lanoke, which is where Aaron Spencer is being held. Aaron Spencer is the father that shot the person that was SAing his daughter, and shot and killed him. Now he's running for sheriff. It's a big high profile case that's in Lonoke County. We were supposed to speak at Lone Oak and serve there, but about 10 minutes before we arrived, they canceled the commission meeting, and so we didn't get in. But we stayed there, and the next day we did Pulaski County, which is Little Rock, Arkansas area. So we did get at least one service in Arkansas done last Tuesday. Then we drove down to Texas, Harris County on Thursday, followed by Fort Bend County, Texas on Thursday as well. So those videos are not out yet. We're working on them. There's not a whole lot going on between now and the end of the year. I mean, we're not going to stop. We're kind of in the middle of the country, Oklahoma, Arkansas, Missouri area. And I'll be looking for places that we can serve, but there's really not a whole lot going on at all. So I am enforcing the law. That's absolutely it. And I'm able to enforce the law. That's what my degree is in, is law enforcement. That's what my oath is actually in, is a law enforcement oath. It's not an administrative oath. So yeah, I'm enforcing the law. I'm law enforcement. You're absolutely right. And my oath coincides with the enforcement of law. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. So that is an enforcement oath, not an administrative oath. You're absolutely right. But there is talk about that coming out of Alabama. We've heard from some state politicians there that there's a lot of talk and chatter about perhaps trying to arrest us on practicing law. And all I got to say is that we've already got attorneys standing by. That I'm not an attorney, but we have attorneys standing by that are ready to snap back on that. So, you know, if that's the way you want to go, Alabama and Florida, all you're going to do there is draw attention to the issue. Because if you put me in a courtroom and give me the opportunity to be able to talk about the shit that I know that you're doing illegally, that's going to be a very, very dangerous place for you to have me. So I would just advise that you guys don't put me into a courtroom, because if you do, it's not going to go good for you at all. Not at all. Because if I have an opportunity to take something to trial, I'm going to be going to trial, and I'm going to be talking about the reason why I'm saying the things I'm saying. And I'm going to let that jury decide whether or not what I'm saying is valid. And if they do, and they find me not guilty, that's going to be called jury nullification. And by that jury nullification, my crime would be nullified, because what I'm saying is true, and that jury will determine that. And thus that would be acting as actually an indictment against those government agents. So I would be really, really cautious about putting me into a courtroom, because if you do, we will absolutely jack your world up, because that's going to give me the audience that I need to be able to put everything I need on the record, and give the people the opportunity to have a pettit jury actually act as a grand jury, because by finding me not guilty, it would be not guilty because government's committed these crimes. And if government's committed the crime, then by the jury nullification, that would actually be an indictment against those agents. So I wouldn't go that direction if I were you. All right, so what was I just talking about? All right, so there's not much going on between now and the end of the year. So I'm going to be focusing a lot on trying to get this disability stuff for my time in the military, the illness and the hospital time we just had. I'm going to try my best to get that because, if I can get the funding from my Service Connect Disability within the next month, then we'll have the funding to be able to actually get this done. As far as I'm concerned, we'll have the ability to get it done. The $200,000 would be just unbelievable, in this pursuit. And so we're going to focus on trying to get that done. But after the first of the year, the thing is that's when all of the state legislatures come back together. That's when they start working on their budget. And so we'll be going to state houses heavily after the first of the year. I am going to be in D.C. January 5th through the 9th for the toll and roll. So toll and roll has asked me to come and work with them. We have some meetings with our own U.S. representatives and one U.S. senator for ourselves and our effort. But we're going to be working with toll and roll in their meetings as well. So you guys want to come on out? We'll be there January 5th through the 9th, and then from there, I think we're going to start another Western loop. We got to be in Michigan, I think on the second week, the end of the second week, and then Minnesota. We've got some meetings up there with a few judges. So that's the immediate schedule. But the next 2 weeks is going to be pretty slow. So I hope you guys have a great Christmas. Jessica and I, we don't have anything, no family, nothing. So I'm not sure what we're going to be doing, but I hope you guys are with your family. I hope you guys have a good Christmas, and I hope you guys stay safe. All right, and we'll be in touch. As soon as the holiday is over, and we're back on the road. Okay, love you all so much. I don't want to say in Michigan yet. We're definitely going to be coming into Detroit and focusing on and getting that county finished. But they have actually a city council meeting every single week in Detroit. I believe it's every Monday. So we'll be able to get in and get Detroit done. Is there any questions here? You guys got some questions? Shoot them up here. Thank you. You guys stay blessed as well. Thank you. No. So we don't help on individual cases. That's something attorneys do. We're advocates. We speak on behalf of others. That's the big difference between an attorney and an advocate. So I'm substantive law, and I'm known as an advocate. So I speak on behalf of others. Attorneys act on behalf of others. When you give someone a power of attorney, they're acting on your behalf. So, an attorney acts on your behalf. They actually take act. I speak on your behalf. So an advocate is one who speaks on behalf of others, particularly in a legal matter. So no, we don't take on individual cases. I'm sorry, but all of the information that we give is all, pertinent information to be able to help you understand your situation and hopefully give you knowledge of ways that you could, attack your own individual case. Although, once again, what I'm doing, this particular litigation that we have in challenging the jurisdiction of the state, it will help you in Blount County or any other county. Thank you, brother. Man, I was sick. I was so sick. Yeah, absolutely. Yeah, I was sick. Okay, 2 hours north of Detroit? Yeah, absolutely. Yeah. All right, guys, I'm gonna let go. Okay, thank you guys so much. God bless everybody. Have a great rest of your day, okay? And again, if you guys have any questions or you want to go back on this video, I know it's been a long one, YouTube. You can go into YouTube and the video will be saved there under my profile. It's my first name and last name. So first name, last name, Tanawa Downing is the YouTube channel. And TikTok isn't saved, but you can also go to my Facebook page. Facebook is Tanawa.Downing.5. All right, Tanawa.Downing.5. And they'll be there for 30 days. All right, guys? Thank you guys so much. God bless. Have a great rest of your day here, okay? Thank you, YouTube. God bless. Thank you, TikTok. Appreciate it, everybody. Thank you. Please continue to like, follow, share our videos. Thank you. All right, Facebook, thank you guys so much. God bless everybody. Please continue to share the videos. That gets us back out in the algorithm and gets out there. Thank you guys so much. God bless.